Hello, welcome to the first of a two-part video series on understanding the role and needs of the attorney, the advocate, and the judge. We're going to look today at an introduction to the topic and to the role and needs of the attorney. Let's have a look at these three key professionals. There are three key professionals when you're dealing with litigation, besides the other expert witnesses, but the other professionals that you will deal with, other types of professions, are the attorney, the advocate, and the judge. Those are really the three key professionals besides the experts. And then let's have a look in respect of each of those at their role, their needs, and let's have a look at a key tip in respect of each of those three professionals. And let's start in this video with the attorney. What's the role of the attorney? The role of the attorney is, in fact, two roles in one, really. Their roles are to prepare and run the trial from the logistics of court perspective and also deal with certain pre-trial processes. What I mean by that is that the attorney is responsible for the sort of administrative or logistical aspect of preparing the matter for court and will always remain within that capacity. But the attorney also, and this becomes increasingly the case in recent years, but will also assume a responsibility where the attorney will run with certain pre-trial processes. So will take care of some of the litigation proceedings in the preparation for trial phase. So for instance, pre-trial conferences, there might be attendances which are required in terms of the rules of court, the preparing of notices in terms of Rule 36 and the like. Attorneys are taking on an increasing responsibility in that regard. But always underlying that is this logistical aspect of the attorney's work, which is very important. It can be actually very complex. Dealing with an administrative and logistical and bureaucratic aspect of things takes a particular skill and a particular mindset and a lot of application. So bear that in mind, that that's where what the attorney's role is. The needs of the attorneys is first and foremost to finalize a matter efficiently on behalf of their client, in order to particularly for plaintiffs, there's a real pressure to get litigation finalized for their client, and also to recover a fee. This is expensive litigation. As soon as you're dealing with experts, by definition, there are a lot of expenses involved, which means a lot of capital outlay, which the attorneys have got to recover. So that's a very real pressure on the attorneys. In order to do that, the attorneys want to settle well or win a trial. So if they can settle well, they're happy with that. But if they can't settle well and you get to a trial, they have to win that trial, because there's such an investment of capital and resources into each trial. A loss is really devastating. In order to win that trial, the attorney needs all role players to properly understand and fulfill their roles. So experts must know what they're supposed to be doing and then do it. And included in that, if the expert comes to an opinion, if they get to court, their opinion has got to then prevail in court. You cannot back away from your opinion, and you cannot have your opinion overturned in court or not followed. It can be devastating for a trial. Any matter in which an expert is testifying, if they get into the witness box, that case can probably turn on that expert's evidence. So it's vital that you get your opinion right, you're able to stand by it and follow it up in court. The attorney also needs to understand the expert's medico-legal opinion and the reasons therefore, and you'll see that's a thread that runs through dealing with all professionals, so that the attorney can negotiate and prepare for trial. You must be able to explain with the attorney, it's a bit more broad brush strokes. They need to understand the essentials of what you're saying, but it must be rooted in practicality. And that's the key tip, really. Your medical knowledge needs to be applied within the context of that particular plaintiff, that particular person, and it must be rooted in the practical reality of South Africa today. So any opinion that you give, for instance, about income earning capacity or about the effect of an injury on a party's life, anything to that effect, or even opinions dealing with negligence, must always be rooted in practical reality and must ultimately make sense. Common sense is important because it affects the probabilities of a matter. That then brings us to the end of this video. If you enjoyed this video, remember that there's plenty of advice and guidance in the Expert Witness Guide. We will send out regular links and advertisements for the Expert Witness Guide. I hope you enjoyed this video. In the next video, we're going to have a look at the role and the needs of the advocate and the judge. Thank you very much for your time.